Hello. Good afternoon, friends. Is it okay to start?
Yes.
We are ready.
I am CS Rajesh Tarpara, Central Council member of the ICSI. Extend warm welcome to all the eminent dignitaries from the MCA and CRC Manesar, our esteemed President in absentia, and all the staffs from the ICSIs and delegates members through attending the webinar through virtual mode. The CRC is an initiative of Ministry of Corporate Affairs, MCA, in the process of re-engineering and government process re-engineering project with a specific objective to provide speedy incorporation related services in the LLP and company sector that will in line with the global practices for the ease of doing business. Ministry of Affairs is continued efforts to promote ease of doing business and enhance the stakeholder awareness, has taken very initiative on organizing today's webinar with jointly ICSI and MCA CRC Manesar for processing and focusing specially on the name availability as well as incorporation of LLPs and companies. When today ICSI president, because of their health issue, he could not be able to join, but this is his initiative to interact with and join hand with the government initiative and also at the same time enhance the transparency in governance sector as well as also helping hand towards the members problem resolutions. And in this way, we are also building a capacity of our members. I would like to thank this president for this giving opportunity. Now, moving forward, we have with us Sanjay Suri, Director General of Corporate Affairs, for his special address. Over to you, sir.
Mr. Sanjay Shori is not coming because of certain pre-commitments.
So, okay. So we have with us Varun BS, Deputy Director, DGCOA, Ministry of Corporate and Sri M. Harshvardhan Reddy, Deputy Director MCA for their appropriate technical and topics words. Also, we have officials from CRC Manesar, Anil Yadav sir, ROC CRC Manesar, Afzar Ali sir, Deputy ROC CRC Manesar, and Srimati Binni Oberoi, ROAC, CRC Manesar for providing technical guidance. So moving ahead with Harshvardhan sir ready for their occasional speech, sir.
Good afternoon, everyone. This session has been designed as suggested by the ICSI members in consultation with the MCA to create awareness among the professionals related to the services provided by the MCA, CRC, particularly related to the name reservation and incorporation services of both companies and LLPs. If you see the last few years, more than 1.5 lakh companies have been incorporated every year. Around 75,000 companies, LLPs are being incorporated, which shows the faster pace of corporatization of India. So every day, the CRC processes around 3,000 to 4,000 e-forms related to this incorporation and name reservation services. They are doing a stupendous job in ensuring the transparency and digitization of the services which were earlier were in the manual mode with the jurisdictional ROCs. With its convenience and simplicity, there are several issues also have been highlighted in the past from the professional community, particularly related to the name reservations. MCA has a policy of certain delivery standards, particularly related to the name reservation and incorporation. As per the standards, CRC processes the e-forms based on the Companies Act and LLP Act and the rules thereunder. I just want to highlight a few things. First is regarding the awareness. Many often the clients take up comes to the professionals based on their requirements. It may be in numerology or astrology, whatever, but it is the responsibility of the professional community, that is the company secretaries, chartered accountants, and the cost accountants, to sensitize the client regarding the what Companies Act says regarding a name, because name is a very subjective thing, and everyone will have their own personal preferences. But the law is very clear. Many a times it prescribes certain kinds of names may not be given because they are reserved for several reasons. Identical names are not given in order to prevent the diversion of business. So it is the responsibility of the professional community to sensitize the clients what kind of names may be given, what kind of names may not be given. Everyone will have their personal preferences, but if it is not as per law, the CRC may not entertain such claims. So it is a great responsibility of the professional community. And the second thing is that it is the responsibility of the institute also to sensitize their members, so that they always take the objective path for the name reservations. Because whenever we have observed that there are two names may be applied in a run form or spice party A form, but mostly those two names will be very close and identical. So if they select two names a little different, that will provide a better opportunity for the ROC officials to process the names accordingly and provide the approval instantly. But what happens, many a times they provide only one name, and that also resembling to an existing name. That leads to a lot of resubmissions and delays. So it will eventually lead to the dissatisfaction among the professional community and the business community. So this is where the role of ICSI comes here. So we request ICSI to sensitize their members regarding the do's and don'ts when they are applying for this names for the LLPs and companies, because the rules are very clear. And recently the MCA has come up with a standard operating procedure for the name reservations, and that has been given to the CRC. So CRC office also sensitizing its officials and officers to maintain the consistency among the names which are being given. Further, grievances. Coming to the grievances, there are several grievances are raised by the professional community. Some of them are technical in nature, some of them are related to the approvals. So I urge the professional community to raise the F4 tickets mostly for the technical reasons. That will be taken up by the e-governance along with its service provider, and we will try to provide the resolution at the earliest. If there is any technical glitch, that will be resolved so that the forms will be processed accordingly. But there has been a trend, it has been observed that professional communities, as soon as they file a particular e-form, they are raising a F4 ticket for the approval. They are saying the form has been pending for last 1 day, 1.5 day. So I request the professional community to understand that all these particular e-forms are processed in a first in, first out manner. So because every day there is a huge inflow of new forms are being filed, it will take a reasonable amount of time may be given to the CRC office for processing as per the rule. So if you raise more and more such tickets without giving the reasonable time to the CRC, those tickets are also have to be resolved by the CRC. So that will divert some of their valuable time for closure of these tickets. So instead, they may give more time for the processing of e-forms. So the MCA requests the professional community to raise the F4 tickets mostly for the technical glitches rather than approval. Yes, if there is any approval which is pending more than a reasonable time, they are very well entitled to raise their concerns. And at the same time, raising the where to raise the grievances. As I said, they can raise that F4 ticket in the MCA portal, or they may send mails to the MCA headquarters or the CRC. Further, there is one institutionalized mechanism has been established by the Ministry of Corporate Affairs. That is a grievance redressal mechanism. So whenever there is a grievance is there, they may very well take up the issue with the MCA headquarters or the CRC concerned. So based on the gravity of the grievance, whether it may be related to the inordinate delay in processing of a particular form, or the kind of arbitrary resubmission remarks, or maybe they are related to unwarranted practices. So those issues may be taken up through grievances. So the grievance redressal mechanism committee, which is also having a your ICSI is also an act, one of the ICSI office bearer is a part of the GRM. So we will take up the appropriate measures, and we'll try to resolve these issues. This is from our side, e-governance division. And if there is any technical issues, or there anything related to the system processes, the questions may be raised, and after the technical presentation is given by the CRC team. Thank you.
Hello. Hello.
Yes, sir.
Yes. Now moving ahead with the proceeding of the webinar. Now I request Sri Varun BS, sir, Deputy Director from DGO CO, please address the gathering.
Hello everyone. So as Harsha has, Deputy Director Harsha has put across the objective of today's webinar, and one hopes that this webinar will go some way in ensuring that the number of resubmissions and common mistakes that are committed by professionals are reduced to a great extent. In fact, a PPT has been prepared by the technical team, addressing all these common queries, common mistakes that are committed by the professionals, which can be avoided to a great extent. This session will hopefully go a long way in clarifying these kind of issues and reducing resubmissions on account of these issues. And I hope most time is dedicated towards the technical session. So without taking much time, let's have more time to the technical session. Thank you.
Thank you. Thank you both the dignitaries and officers from MCA. Thank you, sir, for enlightening us the objective and precautions to be taken by the professionals. Thank you for your words of wisdom. Now moving ahead with the technical session by Anil Yadav, sir, and their team. Sir, Abzar Ali, sir, and Binny Oberoi, sir, over to you, all of you, sir. Please, you may continue, proceed with the technical presentation.
Good afternoon, all. Thanks for your valuable time. My colleague Harsh Reddy, Assistant Director E-Governance, has already briefed you about the objective of the session. So there is nothing much left for us. And to sum up, I'll say this session interaction, I'm thankful to ICSI for organizing this thing. And the objective is, okay, the common reasons why forms are sent for resubmission and eventually leads to rejections also. So today, let's work in together. We will hear your concerns also, and we will also inform you about the common reasons we'll discuss, so that we can deliver faster services and as per rules. So without wasting much time, already some lot of time has been we have covered. So I'm giving the PPT. PPT will be presented by my colleagues Afsar Ali and Binny Madam.
Good evening, all of you.
Now we present PPT and some common concern raised by the stakeholders, and we feel some mistakes from the stakeholders. Now we will present in the PPT.
Good afternoon, everyone. Actually, the CRC, has contributed a significant increase in incorporation of companies and LLPs. First, we start from name reservation. There are three categories where name reservation fall. The first one is name which is identical. Here, the identical means exactly the same name which the CRC cannot allow if there is an existing company. The second one is where the name resembles too nearly to the name of existing companies. There are certain parameters in the rule itself which define which parameter lead to resemble of a name, proposed name with an existing company. The third one is the use of name will constitute an offense under any law for the time being in force. That is prohibited under certain act. The third one is the name which is undesirable in the opinion of central government, which will also take in detail. And the last one is the names which having government patronism, which are connected with the central government or state governments, that will also take in detail. The test for too nearly resembles, there is a list given in Rule 8.2, which we have to apply. The list is exhaustive names. There is no other parameter for checking resemblance, too nearly resembles the name with the applied name and the existing name. The list already given in the rule itself. So I really, urge to first that list. It will not fall in any of the. Is it audible? Okay, let's check. छुट्टी बैठे
With your presentation, ma'am.
Binny ma'am, I think there is some internet connectivity issue at your end, which is why video is being stuck and audio is also not there. I think there is some issue at the CRC and we need to wait for 5 minutes.
There is issue with CRC, madam?
Yes, there's some internet connectivity with CRC.
Member भी वही सोच रहे होंगे.
Yes, it's
Now
audible
it is audible?
and you're visible clearly. So we can start. You can have in the slideshow mode, the PPT.
Okay. So the undesirable names is also very important. Yes. It's very useful if the proposed name already have registered trademark, then the CRC will not approve the application. The form will went for resubmission. So please check the trademark before applying for the name. The second thing is if the proposed name is identical with or too nearly resemble with the company or LLP incorporated outside India, then also we are not giving the name. Or if the proposed name is identical with the name of the company or LLP which has been dissolved or struck off, or there is a case of name change, a specified time period has been given in the rule itself, and if the time period has not been elapsed, then the name cannot be approved from this site. And the another one is the descriptive names. This is very commonly used, commonly query which CRC is going to deal with. The descriptive here describe the name which described an activity and also commonly used words. Here, if the proposed name contain only the activity and which is also a commonly used words, it's not necessary that it will describe the activity which the stakeholder has applied, any activity. The name is descriptive. Here we have listed some examples like Sales Line Distribution Private Limited, Garage Wala Private Limited, Artificial Intelligence Private Limited. These are some examples. This is not the only examples. This is some examples which deals with descriptive names which applicant on daily basis filed in the office of CRC.
Let me elaborate a little bit on these descriptive names. See, let's take example of Sales Line Distribution Private Limited. See, sales is an activity. It is activity of various companies. So if we give the sales word itself as a name of the company, then the rule provides that it is a descriptive. Same is the case with the garage. There are a lot of companies dealing with the car, automobile sector, which has the garage wala thing. Same artificial intelligence. So this is one of the IT thing which is going on and it will grow. So giving artificial intelligence, entire activity is given as a name to a company. So these are prohibited by law. And whatever we are trying to do is to adhere to the law 100%.
Yeah. And the names which basically applied by Section 8 companies or maybe some other companies also, which give the impression of a government patronage, that name is not going to be allowed by CRC as per Section 4.3 of the Companies Act. Here we have listed some of the illustrations for the professionals like MSME Indian Chambers of Commerce and Industries, Bharat Atomic Labs Private Limited, Digital Bharat Private Limited. These all are the names which give impression like companies associated with some of the central government or state government or have some government subscriber in these companies to the stakeholder, to the general public. That's why we are not going to allow these names. And these Rule 4.3a of the Companies Act specifically prohibit proposed names which give impression to the stakeholder or to the general public that this company may belongs to some government, some state government, or some central governments. So I request stakeholder to kindly not to apply such names.
In this patronage clause given in the rules, it is specifically said that impression. So it is not that a single word is There we do have a list of words which are prohibited, which is given separately, but even then 4.3a provides the impression. So it is a combination of words which gives inference that says this entity is somehow related with the central government or state government or a local body. That's why, see, we have coined some examples also. Let's take Digital Bharat. So Digital Bharat is an initiative of a government. It has always been a sector, digitalization, laying of internet infrastructure. It has always been a government's initiative, and it always will be. That's why such activities, such combination of word is not allowed as per rules also, so that the public in general is not confused whether it's a government undertaking or it's a private thing. Similarly is the case with Bharat Atomic. So these are sectors which gives impression of government patronage. So we'll go ahead. The whole point is that it should not give patronage, government association with the or to general public.
Okay, the next one is the use of different phonological spellings, including use of misspelled. We have seen a lot of time there's a numerous application flooded with the name, applied name, and the existing name, which phonetically are same. Spellings are different, but at the end, the phonetical spells, they sound same. We have listed some of the examples for the professionals to go through it. Because if the spellings are different, they are able to file the form. But ultimately, if we check the resemblance, they fall under too nearly resembles. Now we would just like to discuss some common made errors which the professionals or applicant file with the form which we deal in CRC. The first one I would like to take trademark related issues. Here we have seen number of times the NIC select the name contains any word having trademark in same line of business. Like if they already existing name, like there's a name of ABC which already is doing retail or wholesale in clothing, and if the proposed name also deals with retail or wholesaling of clothing, then the trademark query will definitely, we have to raise the trademark query. And if we have raised the trademark query, it's a request from the stakeholder. If they already have a NOC from the trademark holder, kindly attach that NOC and also the self-attested copy of PAN card of TM holder. Number of times they only attach NOC. They don't attach the self-attested copy of PAN of TM holder. So in case if the trademark holder is a body corporate, then also we require NOC, and that NOC should be in the form of board resolution along with a copy of PAN of body corporates.
See, why we are asking for PAN of the body, corporate or individual in case of providing NOC, because we have come across certain cases, a number of cases where it is found that the NOC provided is not genuine. People have just written on a piece of paper, signed on the in the name of the proprietor or the holder of the TM, and yeah, they have just submitted it. So just to differentiate between a genuine NOC and a forged one, we need it. This is a kind of check, security check which we implement, and that is in the interest of the public.
Yes. Now I would like to take up certain NICs where detailed objects are definitely required for checking the TM, because basically some of the cases they only write the NIC which is very general, like other business support service activity. We are not able to see what other business support service activity the proposed company. We have to check all the class of businesses and we have to get into resubmission, because someone it fall with any of the line of businesses with the proposed name registered in TM. So it's a request if the NIC is general, like manufacture of other articles. What articles? So kindly attach the main proposed objects in order to identify the TM query in first instance. It will definitely reduce the resubmission, benefit to the stakeholder and for the office of CRC also. Another issue is NIC selected by the stakeholder mismatch with the proposed object submitted during name reservations. Like they already attached the object for retail, but they are choosing, selecting the NIC for the manufacturing and retail both. So this will mismatch the proposed objects and the NIC selected in the form. So it will ultimately lead to resubmissions. The another one is multiple SRNs for the same names filed by the stakeholders, which are not allowed. If one application is under resubmission or under processing, we cannot able to process the another application with the same name. It will lead to multiplication of SRN, lead to wastage of resources from your end also and from CRC also. And the commonly mistake which we have seen, file section 8 companies, when they apply for the proposed name, they will not use the words like association, federation.
You are not audible, ma'am.
To use these words instead of private limited, they have to use the association, federation, council, association, and extra words which are already listed in the.
Okay. It's switched on. Whether are you able to see now? Am I audible? Video is not. Let's try to fix it. देखो सुशील क्या हुआ?
Yeah, now it's visible. Yeah, can we carry forward?
यार ऐसे मैं मीटिंग में बैठा हूँ, ऑनलाइन चल रही है, उसमें भी आप बच्चे भेज रहे हो मेरे पास। कोई बच्चा जल्दी जाए तो थोड़े डिसीजन लो के पास क्या और ये
current slide.
Okay.
Latest is the current slide.
किसको बताना तो मेरा
Yes. Yes. We'll take you there. Just a minute.
Yeah.
So we were saying कि in case of Section 8 companies, the requirement of Rule 8(1)(u) provides specifically that a Section 8 company must have the word association, federation, council, forum, and certain things are given. So in that case, even I will request all the learned listeners that see, rule is quite absolutely clear. So there is no ambiguity in this case. So I'll request, even if the stakeholder also is incorporating this body, if they are insisting, even then I request you to educate them. This word is actually required. So because it is also in a number of cases we have seen such name comes, proposed names comes without this 8(1)(a)
trust.
So we have to send it back. So it is also causing duplicacy of work. So this is an earnest request from all of you.
Yeah, as financial activities are allowed for the companies, but some of the companies are selecting option as a Nidhi company. As you all know now, For incorporating a Nidhi company, MCA headquarters central government approval is required. So kindly do not select option of a Nidhi company with the NIC 64 and 66. The next point which I would like to take is the NIC 64 objects. If the company proposed object is related to purely financials, that is finance, investments, all these proposed objects are there, then they have to choose NIC 64 and their name should stand alone, use the word finance or capital or investment or the list which is provided in the rule. Without using these words, we will not allow companies to do financial objects. It's very clear in the rule itself. So kindly use the word of finance stand alone in the proposed name if the NIC is 64. Here some of stakeholders get confused. If they have chosen NIC 66 also, they are applying the standalone name with finance, like ABC Finance Private Limited. This is not allowed if your activity is NIC 66, that is ancillary to financial objects. Here, with the word finance, you have to use a non-activity word also, non-financial activity word also. Like if the name is ABC Financials Private Limited, the company has to apply with ABC Financial Services Private Limited if the NIC is 66. If the NIC is 64, yeah, the definitely company can apply with ABC Financial Private Limited. This is very clear in the rule itself.
One request also for INC 64, it is sometimes the stakeholder file give the declaration and 8A1G, 8A1C. It is requested to all the learned stakeholders that a declaration also be attached with the NIC 64 rule 8A1P. Sometimes they don't file, so form go into the submission or rejection. In NBFC company, it is more frequent mistake. So it is requested if they choose finance word, so they also should take the 64 NIC and also attach declaration.
Declaration to the extent that you won't be doing any NBFC activity.
Yes. Declaration
Without
under rule
secretarial
8A1P that they will comply on all regulatory body.
Sectoral regulatory approval. Thank you.
Next, there is one issue, architect word. In our ministry issued circular that architect word or in main object or in proposed name, and there is circular that word will not be given. In the clear, it is clear in the, but in 2012 ministry issued circular, but it has not been withdrawn, so we are following it. Or we have also read the architect act. They don't give the architect word to the company or just like LLP corporate entity. They say that architect word be used by only individual person. So this word is not allowed as per ministry guidelines.
Yeah. In case of name change application filed by the stakeholder, we have seen various times that they did not attach board resolution for the name change. If the company wants to change its name, it's a basic requirement that they have to pass board resolution and they have to attach it with the run form. And similarly, in the case of LLP, consent from all the designated partners are mandatory required, which should be in the form of board resolution, not on a plain paper or generally they sign and give their consent. It should be in the format of board resolution.
In
all, not one designated.
By all designated
partners.
So
in case of company is regulated by authority, just like RBI, SEBI, so we need prior approval from the regulator in case of name change. One thing I also requested, if company is changing its name, so they also file board resolution and also MOA. It is too much difficult when name is different, too much difficult to check the trademark of the company. So it makes form in resubmission. It takes time. Sometimes system does not work, system slow. So our dealing hands send form in resubmission that MOA is not attached. So kindly attach MOA and board resolution along with form.
here I would like to also say that if the existing object of the company or LLP is already in the nature of financing investment, and now the company wants to change its name, and they first have to alter their objects, like you have to delete your financial or investment activity, then only you can change the name and delete the financial word from the proposed name. There are certain NICs which are not allowed for LLP or company unless they are related to government sectors. So kindly do not choose these NICs and submit the form with a request to approve it. It's unnecessary, hurdle for the stakeholders.
These are certain. Kindly have a look of these NICs, for which we are repeatedly asking and sending back the forms, the stakeholder to change these NICs. We are allowing. This is prescribed as per the rules that these are allowed for governance sector. So kindly note of all these. You can take a screenshot or whatever, not to use these NIC codes. I'm pausing for a few seconds so that take a screenshot or snapshot of this thing. Okay, we are moving ahead.
So now we can take commonly mistakes regarding processing of application for incorporation, whether it's a company or an LLP. Like the very first thing which I would like to say, like if there is a certain objects which has been approved in SPICE Part A, now the company would file SPICE Part B, and what they will do, they will choose another NIC, or they will write in its MOA another objects which not been approved SPICE Part A, which further leads to resubmissions. There is an illustration which we have mentioned, like NIC choose the time of name approval, they have chosen for retail or wholesaling of certain goods. Now in the form 33 in the MOA, they have mentioned retail, wholesale and manufacturing activities, which are not allowed in later stage also. The other point is provide COA and PAN card of the body corporate which is proposed subscriber to the memoranda. If the subscriber of the company is a body corporate, then kindly provide certificate of incorporation, PAN card of that body corporate. Similarly, to avoid forgery or some kind of fraud. It's for in the interest of public itself. And another point which is very important, prior approval of MH is required in case the proposed director of the proposed company are from land sharing countries.
MHA approval is required. If the company is incorporated outside, company is subsidiary of incorporated outside the company, then we need documents, apostille, notarized. As you know, you are landed persons. How company are, from where, if company is related to the Hague Convention, so documents are to be apostilled and notarized. One problem I see that director are the national having nationality from the outside India, but he is Indian origin. So we have difficulty how to we need business visa from them. Yeah. If they have OCI, if they have OCI, so we allow for incorporation of the company.
Yes. If Section 8 companies are not allowed to do finance commercial activity, many times it has been seen in the memorandum of Section 8 company, the stakeholder mentioned that it will also do some commercial activity or some finance related or some investment or some sale of share purchase activities. Such type of activities are not allowed. And also kindly provide the expected income and expenditure statement as per rule duly signed by all the proposed directors. And Section 8 company shall also not do microfinance activity. In the name it's allowed, but subject to the significance and declaration, but in the objects it's not allowed.
Some applicants say that the Section 8 company why cannot do the business of selling car and other business activities. We say that it is the Section 8 company is related to the promotion of such activity, not the applicant company cannot do the business. It is just promotion. So they should select the NIC code related to the promotion of the object as mentioned in the Section 8 company.
various time it has been seen that various OPC companies are also making application, and in its MOA they are writing that they will do some an investment or NBFC activities that is totally prohibited as per the rule and the act and the Companies Act. And another thing which I would like to say, in the case of registered office address or a residential proof address of director subscriber, the address proof should not be older than 2 months. Sometimes they will attach 6 month older or 1 year older or 7 or 8 months older address, which are not allowed because of to how we can cross check whether the address is true or not. So we are only allowing only 2 months older utility bill or something, a bank statement or whatever, it should not be older than 2 months. KYC for, in case the post director doesn't have the DIN, then we want to do KYC documents required by the stakeholders. So that KYC document shall require Aadhaar card, driving license, passport. Sometimes the user only give the PAN. So we want Aadhaar card, driving license, and passport as a KYC documents because it only includes the address.
Seeing in the CRC that the stakeholder file wrong registered office address in Part B form. If I request to all stakeholders or learned professionals that if they don't have complete address, they should tick the no in Part B form, point number 4B. So it will be it makes more resubmission in the form. And so I request all of you that if you have not correct address, so you should tick the no in 4B point of the Part B form. So it will reduce the resubmission. Another point is that sometimes address is related to the village. We don't understand village, where is village, so we should there is no plot number, flat number, so we should write that the care of who is the owner of premises, so we should write them that care of XYZ, care of Afsar Ali, and address Mohalla Falana XYZ. In this way we can reduce the resubmission and stakeholder will be company
Yes.
will be incorporated early.
Yes. So, in case of conversion cases, we have seen that companies, has made advertisement in URC2 format, but they are unable to file URC1 form within the time specified in the rule itself. So it's a request that kindly, make your arrangement to file all the applications, all the incorporation documents within the time frame, so that the time which within the 15 or 30 days of the period of advertisement do not lapse. And in case of producer company, we want a producer certificate for all the subscribers certified by the agriculture officer or SDM or district administrator, and it should be on the letterhead of of the government department, having the file number, address, proper phone number, name and seal. Otherwise, it will be very difficult for us to find out whether it's a forgery document or it's a true. So we just need on the letterhead of the government department. And related to LLP, we have seen that various LLPs, in its object, after incorporating LLP in Form 3, they will include NBFC or investment activities which are not allowed. We are not allowing LLP to do the NBFC or investment relating activities at the time of incorporation also, and at the time of form filing, it's LLP agreement also. And the last but not the least, the major mistake in the LLP form which we have seen, like if the DPIN does not have proposed designated partner does not have their DPIN number, so they have to file the consent in a specific format of Form 9 with fill-up form. What they will do, they will only fill the web Form 9 of for those which having DIN number, but for those which don't have DIN number, they will not attach the consent in the prescribed form. And this is a many times we have to send this form of LLP in the resubmission on this remarks that kindly attach consent of all the designated partners. It should be attached with the fill-up form. And the last one, there is some Aadhaar entered already exit against deactivated due to non-filing of DIR3 KYC. So if the KYC is pending for the proposed directors or designated partners, in the end the form will not going to be approved. So it's mandatory for you to complete your KYC details.
However, FC1 are very low in number, but we have seen some problems in the FC1. So form has to be filed in the establishment of only only 4 reasons FC1 are filed: and license office, project office, branch office, and other office. Sometimes company are subsidiary, but they are filing FC1. So there's some mistake, subsidiary company filing in FC1. So they should make the subsidiary in India. If they want license office, project office, so they should file the FC1 form. And because a license office, so NIC to be selected in the form should be in accordance with the activities that are allowed to license office in India by Bank of India. Where any office of document filing is not in the English, there shall be attached translation thereof in the English language duly certified as per the provision. And it should be certified. Following documents are to be notarized, consularized as the case may be. Copy of charter of MOA, AOA, list of the directors, power of attorney, board resolution, authorized person, and other are related to the Companies Act. Detail mentioned in the list of the director to be attached in the form should be as per rule 3 of the Companies Registration of Foreign Companies Rule 2014. Stakeholders should file the form after ensuring that whether the foreign company is from a country which is a part of Hague Convention or not, and accordingly make the compliances. Stakeholders should attach RBI approval in FC1 also. In case if no such approval is required, then a declaration from the authorized representative of such foreign company should be attached that no such approval is required, as per Rule 33 of Companies Registration of Foreign Companies Rule 2014. Thank you. Now we are ready for your questions. We have received some questions from the ICSI to give answer.
Yes.
So that it may reduce the.
Sir, just can you stop the
rejection?
share of the screen? Okay, yes. Is it
Yes,
audible? Audible?
Absolutely.
So can we start with the few question
Yes,
answer which
sure.
were already shared with you? Can I take up one by one?
Yes.
Okay. Question number 1, which was received from the stakeholder, that is a procedure for cancellation of approved name. Because even of ticket raising, the same stereotype request is coming, remarks is coming. Kindly wait for the expiry of original name, even though we are submitting affidavit and all. So there must be some robust system, because some technical mistake की वजह से कभी हमको कोई नाम मिल जाता है वो, और हमें वो चेंज करना या नहीं चाहिए, हम दूसरे नाम से जा रहे हैं, तो there must be some facility to go out easily withdrawal of the name. That is the question.
So withdrawal.
Can I repeat?
Name,
Can I repeat again?
Yes, please come once again.
So do you need to repeat it again, or you got the question?
Yes, sir.
Yes, question. Please come up with the.
आपका voice break हो रहा है sir. Myself is not audible. Okay. So my question again, I'm repeating, once the name is approved, but due to certain typographical mistake or whatever reason, we want to withdraw it immediately, right? After just getting the approval letter. So there is no as of now facility apart from submitting affidavit and raising the tickets and all that. और lastly हम एक ही चीज पाते हैं कि भाई please wait till the time of the name of the expiry of the name. So there should be some facility. That is what is exactly the question. I think technical team is having technical problem. can you pause your video? Can you off your video and then continue with voice facility only? There can be some easy.
Okay. Yes, yes. The concern duly taken. Yeah, the concern has already reached the highest level. Yes.
They two issue in LLP 90 days are given after the name approval, and in Part A run form we give 20 days up to 60 days. But there is a issue. We don't know about the name of the person who is filing. Just accept the receipt.
Already taken cognizance of this issue. Some of the stakeholders has reached the ministry, so some rule in this regard may come up very soon. In as such case come, you can just
They
take
can
from the applicant
who has the challan receipt.
with adequate supporting documents to prove that the name which you are going to withdraw or you want a case to case we may look subject to we will see not actually not as of now not formalized. Next question.
Sir, but my just logical
Yes, sir.
and legal
Yes.
submission over this is that when you are allowing the name approval, which is only on the ownership of the user who has filed the name, right?
Yes.
There is no any cross connection, direct connection with the directors, promoters, whatever there to be proposed with this name, right? There is no facility. So withdrawal is also rest with that user only, or allowing the name is rest with that user only. So putting that hardship may not be required. Just it is an open thought. You can look into this because once you allow the name to a particular professional or particular director who has used their login ID while applying the run for name availability, and again he is himself is coming for withdrawal from the same ID. So there is still no clear-cut identification who is behind this, who is going to incorporate this company. It is none of our business at this juncture. Maybe there cannot be any problem if it is done.
So the solution which you are thinking is from the angle that we should have a mechanism, formal mechanism to withdraw the name. That's why in such situation, ID proof and this login ID is required. What I am talking is, see, as I told you, the ministry is always seized of this matter. They are thinking on these lines. But as an interim measure, what I suggested till the time e-governance comes up, or e-governance may like to reply at what stage it is. Till the time the ministry comes with this solution as an interim measure, in such cases I have suggested this course of action. You can come up with the affidavit.
Affidavit is also already sometimes submit, even though remarks are coming that please wait till the expiry.
Stakeholder.
It is also cases in the question. Affidavit is already submitted, and affidavit is always with KYC document of the proposed director, right? Or the users of the ID, whatever. But this should be looked at and
We will
affidavit hai to please immediately
we will take up with the
note of
policy.
this.
We will take up with the policy section. Accordingly, we will make a online provision or any some service for the withdrawal of the names which are already been given. If there is any defect.
Yes, that can be possible, right?
Yes.
Now,
yes,
second question. There is an LLP would want to convert into private limited with the same name, which is already with LLP, right?
Yes.
But the query again and again is coming that the proposed name is resemble and so on and same name and LLP name and the proposed company name cannot be same, cannot remain the same. These kind of the queries are coming. Even after resubmission, we are clarifying the same thing, even though lastly remarks aa jati hai ki bhai this cannot be possible, kindly phonetically resemble and like that remarks are coming.
So your question is whether this glitch is you are facing at the time of filing the form, uploading the form, whether it's system based error or whether it is a remark you have received from CRC.
It is a remarks received from CRC also, and it is a remarks by auto-populated while filing, and after submission also there is a remarks.
See, auto-populated thing when at the stage of filing, if you encounter such kind of error alerts, so you better take screenshot and reach out to e-governance cell. But vis-a-vis CRC, once this application is received by CRC and we are processing it, in case you come across, so I'll request you to write an email to roc.crc and ask crc.escalation. So because see, we have a big team and we don't know if such error has come. So maybe if at all I take whatever you are saying on words, there might be some misunderstanding or misinformation or misinterpretation also is possible. So better you send an email to roc.crc@mca.gov.in and crc.escalation@mca.gov. I'll personally look into this matter, such kind of matter. Every day I check each and every mail, but some mails remain unresponded because some people seek opinion. So which opinion we are not entitled to give. Secondly, certain things are categorically mentioned in the rules. So in such cases also, but vis-a-vis any remark which we have given, we do take concern of all these things.
Sir, but irony is that the mail has already been given in this particular case, that CRC escalation and all that they have already mailed, and mail पे उसको reply है कि I the proposed name is exactly nearby phonetically resemble, hence not considered as per the rules.
So to
तो ये
the
चीजें सर ऑलरेडी मेल पे भी लिखते हैं
कोई
यूजर्स,
बात
बट
नहीं,
फिर भी वही आंसर मिल रहा है,
inconvenience in
प्रॉब्लम
this
ये है.
matter. So whosoever has raised this question, we are apologetic to him. Then inconvenience caused is regretted. You once again send this email, or you can refer this today's webinar also, and kindly send the mail. We are here just to
So
see
user might be aware about this answer, so he may
enhance
write again,
coordination
right?
and smoothen any our association. The whole purpose of this webinar is this.
Okay. And the name application rejected, insisting the company should obtain NOC from SEBI since the name contain word exchange in the new name, right? The company is regulated by RBI only with valid AD category 2 license issued by RBI and nothing to do with as per rules with the SEBI. So how the circular override the provision of the Act Rule 8A sub rule by P? Hello.
Yeah, hello.
There was some network glitch. Can you come up with the question once again?
Sir, the new name applied is having word exchange in the new name, right? The query raised by CRC is that please obtain approval or NOC from SEBI. However, we have nothing to do with the SEBI because we have regulated by RBI having valid AD category 2 license.
And Ministry has issued one circular in this regard. If 8% we cannot see you, if you mail us, so we will provide you that. If proposed name has stock, exchange word, stock exchange word, so name is not allowed as there is rule. Proposed name include word such as insurance, bank, stock exchange.
There is only exchange, Sir, in this case, it is only exchange.
In circular, it is mentioned. I remember that it is mentioned stock also, sir. If we have any issue, or then we seek clarification from the ministry. We note down.
In this case, you should communicate ministry. What is only if it is used as an exchange, not full word.
Sir, but if exchange is used with a NIC 64 with the financial objects, then also we will consider it as a stock exchange. Right? If the object is in the nature of NBFC or investment or finance, if the NIC is 64 and the name include the word exchange, then we require SEBI approval.
As per the questions, they said that the SEBI has no role to play in these matter since RBI is sole regulatory authority for us. वो कैसे वहां जाते हैं, कैसे वहां से NOC ले पाएंगे, that is the problem. That is deadlock.
So in this case,
since I am not controlled or regulated by particular authority, how can I obtain NOC from them?
see in this, what on the basis of questions, what I understand is that this particular stakeholder is into the business of money exchange. So that's why they are saying ki, they have RBI guidelines to follow instead of SEBI. So in this also, we will get back to you on this point. You can mail us. We will get back to you. If it is at all it is prohibited, we will give you the reasons. If it is not prohibited, we will give you the name. That's it. So it's not that we are debating against anything. We are here to note your concerns and also tell you our concerns.
Okay. Next question is, sir, can a company be incorporated for a sole object of share trading in open market? What would be the relevant NIC code for the same? Two questions are there.
Yes, sir. Please again, sir.
Can be a company incorporated with a sole object of market trading, share market trading in an open market, and what would be the NIC code for the same?
NIC will be the 64.
Okay, and so answer is affirmative. Like company can be incorporated with objective to trade shares and security.
Sectoral regulators approval.
Yeah. And
Okay,
the name
subject
also,
to that, of course.
and the name also should reflect the financial word in the proposed name.
Financial, so trading in the security also required financial word.
Such type of
Otherwise,
the
the RBI will get into picture, but RBI is no help to tell you.
Such type of the word which trading shows.
Okay, but in remarks, use the word proper. वो सब remarks आते हैं फिर.
Sir, we are here to hear your grievances. Then we will resolve something. We have no issue, sir.
But in this kind of the webinar, sir, we can interact and we can
Yes, sir,
based on the argument and sub argument and sub thought, we can solve this. But while dealing with the portal, machines, the person who is to whom we are dealing, we are not aware, and it is even not proposed to. We should interact with the person in person because of the system-based process. But in system-based process, what we are conveying, they are either not understanding. What they are conveying, the professional or the stakeholder may not be understanding, and because of that, ultimately the deadlock arise or rejection happens or delay happens. This is what is exactly. So the robust or proper check and balance and rules
we are trying
there for your SOP level.
Sir, we are doing 4,000 form average daily. So we are trying to improve our best, giving our best with quality. So in coming days, you will see it, sir.
Okay. Now next question, not able to run for a availability of conversion of LLP into company, though the entity filed all regulatory statutory documents and master data show all correctly active and so.
Sir, excuse me. We have been sent one queries, one questions. If you go one by one, so it will be easy for us to read the question, because on you speak something, we receive something. So if you please read that.
आपके पास कौन सा पेपर होगा वो मुझे
CRC webinar questions.
Okay. So I am reading the question number 4.
Yes, sir. Please,
I am reading the question number 4.
Yes, sir. Please.
We have registered trademark under name Sun King since 2014, and we want to change the name of our company in the line with the trademark which we are already having since 2014, Sun King. But the remarks says that the Sun King Services Private Limited and Sun King Enterprise Private Limited, which was incorporated later than our trademark, though the same is similarity showing, and name was not allowed to us. So what is the procedure for getting this name? Because our trademark is prior to this incorporation.
Okay. So you can file it with this clarification. We will look into it. Prima facie on what you have stated, the case has a merit. We'll look into it. Maybe filed.
But that all the dealing officers should be conveyed in these kind of the similarity. The period should be checked since which they are using.
And one more thing, I would like to clarify that once, see, the stakeholder was having a trademark, but then a company is incorporated. If it is resembling, so see, if something has happened in the past, doesn't mean how we will rectify. Now, today there is, let's say, for example, there is a company with the same name, and now somebody is coming with the same name. So it is prohibited in rule. We can't undo the incorporation which has happened in the past. So it will depend upon the case to case. So what I'll request, prima facie, this appears to be a genuine case, you may file it.
Okay. Now, question number 5, not able to upload run for the name availability of conversion of LLP into.
These questions are different.
Sir, are you referring to questions which has been raised to you during the webinar, or the one which is shared, which has been shared with
Previously
us?
said. Previously said.
They are different.
I think serial order is different, because
Okay.
can somebody, Deepa madam, if she can intervene and tell us if you have a different sheet.
Surbi madam.
Yes, sir.
So the question which I have already given, you have given to me, which I am
Sir,
referring.
in your list, the above 4 questions were given to you later on. These 4 questions were not shared with the CRC. So they must have received from questions from 5th number.
So, sir,
for me, the 5th is one for them.
Just a second. What I'll do is I'll share the revised question with the CRC team in the chat box. Or so Deepa ma'am will share it over WhatsApp. Just a second.
So, sir, you start from 5th question.
Just give me 2 minutes. I'm sharing the details with this with the.
Sir, in meantime, just I have one question. This that may not be there in the system.
Yes.
Is regard to the address of registered office, what are the practical difficulties is in case we have complete proof of documentary evidence like utility bill, ownership documents, registry document is there also with us. But the problem is that still the utility bill contains the name of the builder, and builder sometimes happens to be LLP or whatever infra companies, right? So the stereotype answer or remarks is coming that the please obtain NOC from so and so, their LLP agreement ले आइए, उसके PAN card ले आइए, वो सब डालने के. So we are actually the owner of the property. Just the reason is that the utility bill is still having the name of the builder who has created the whole infrastructure from which we have purchased the document. We have already submitted the document evidencing our ownership. And in clarification letter, we are also writing that this property has been purchased by us on so and so date. White document attached with this.
Sir,
ये चीज वहां कन्वे होनी चाहिए कि ये बिल्डर का नाम है, तो हमें अलाउ करना चाहिए.
Sir, yes, absolutely. Let me answer your question. See, you have the stakeholder stated that stereotypically, it's not stereotypically. This is first level of check. First of all, we are doing this kind in the, because there has been n number of cases, and 2 weeks back, 3 weeks back, there was a news article also regarding some cases unearthed in Pune, where people were, and it was reported in a leading newspaper, I believe Times of India, that people in Pune are giving registered office proof bogus. So how will we distinguish between? So in such cases, if they have this something, the utility bill which is in the name of the builder, they can give us the lease. They might be having some documentary proof of the ownership of the property. 1, 2, they may have internet connection which might be in their name. Some connection, something must be there. And if they don't have anything, then how will we trust, sir? See, just
we are
see
submitting
other
all
side of
these
the
three
table.
documents.
Just see our plight. How can we trust that this is the genuine registered office NOC or not? So at least we need something to step upon.
I am saying I have already submitted my ownership document along with the clarification
Okay.
letter.
Okay.
I am saying already submitted, even though we are getting same remarks.
No.
Already I am submitting index copies which are available in, let's say in Gujarat, index copies there, or possession letter, allotment letter, dastavej, that is deed, sell deed.
Right.
Property we are also attaching it, even though NOC is demanded from the builder. अब बिना जब उसने मुझे प्रॉपर्टी बेच दी है, मेरा सेल डीड भी बन गया, अब बिल्डर
जी।
2 साल से उधर है भी नहीं, उस प्रीमाइसिस को मैनेज भी नहीं कर रहा है, तो भी मुझे बिल्डर से NOC लेके लेने जाना पड़ता है. तो that is something what look into.
So this is asked because at some point of time in past you have this property and you are having this thing, photocopy of that property. Thereafter the property is sold back to someone. Why we ask for utility bill which is 2 month older, currently, just to ensure that currently it is also in your position. See, resale of properties do take place. That is the reason why we ask for utility bill. So if somebody is saying ki I have purchased the property 2 years back, and then there's natural question ki if it has been purchased by you 2 years back, why the utility bill is still not in your name? It is this is also abnormal. Kindly take note of this. So, but then as I said, it depends on case to case. So we will definitely, we are also here to correct ourselves, whatever glitches are there on our part. We are here to rectify, but then kindly see that these remarks are not discretionary in nature. They have some backing, and these are only to protect the general public. Still, we will request. But then
Okay.
at some point of time, they have to.
Anil sir, Anil sir, I have shared the recent questions over WhatsApp. Deepa ma'am must have shared with you.
Okay, I'll see to it.
So let's go. Sir, one request: a lot of form are sent for resubmission because of this glitch. So I request all of you that please tick no on the nose part, 4B of part B, that you will change register after 1 month.
Within 1 month. We submit within 1 month, right?
So it will be easy. All of us.
But decision, in other words, decision shortcut, right?
You know,
to
sir,
bypass the incorporation query.
we are also limited to the rules, sir. It also says that, but we are not the next question, sir. Please, sir.
Okay, no problem. So I am just referring question number 6. While applying name reservation, do we have some commonly reasons for resubmission or rejection in hand so that user can go through it and then take care in advance? So we should come out with these kind of the common reasons.
Sir, we have discussed common reason in the PPT also.
Okay.
That we check we should first of all we should check the name resemblance, trademark, NIC code, attachment. Almost we attach the documents. Lot of object we put in the attachment.
Phonetically resemblance. People do a lot of innovation in changing the spellings and asking for the same name. That innovation is absolutely appreciable, but not approvable.
Got it, sir. Agree. Next question. Why the second word in the name is checked with the trademark? Let's say, for example, Geo Mining Private Limited. Remarks sent by CRC, Geo is similar to Geo.
Yes.
So is it so? Is it possible?
Phonetically, how will you pronounce? My question is how will you
second question. The user, the person who is asked the question is get the second number, word in the name. So each and every words are to be checked, or only one first word or second word?
Every unique word is checked.
Rule contains that proposed name includes the word trademark, so and so. Includes the word. That means every word has to be checked.
Whether it is prefix or middle or suffix.
Between.
Okay. we should take care of this.
I request.
Next question.
This actually is a very good question, and it leads to a very high number of resubmissions. And my learned friends know this thing.
Yes, we will take care of this. So now we have to check each and every words for the trademark recently and name recently. Moving to next question, that is character limit of 75 characters are allowed in a name availability. But what if my existing partnership firm having names of more than 75 characters, which I want to convert into company?
This concern may be taken up directly with e-governance cell, or Harsha, if you are in the meeting, I request you to take note of it.
Can you please repeat the question, sir?
Harsha sir is saying, in case of partnership firm converting into a LLP or private limited company, the maximum limit of members is 75.
Character limit is there, so
Character
this is restricting, because existing name is very used or having more than 75 characters.
Not audible. Character limit of 75 words.
This may be enhanced to say 200.
Okay, I will take up with the team, sir.
It's not a big deal.
I'll take up, sir.
Please note it.
Next question is 9 number. The name of company includes and associates was rejected by reason that it show particular type of business nature like CS firms. So remove the and word from the proposed name. But how the further the nature of business may be there, like other consultancies firms, which might use the word and associates, or like accounting services, taxation services, they can use that. So what are the courses available?
If we have no objection in and associate word, if they take prior approval from the regulator institute,
but they are not company secretary or chartered accountant or CA. They are just MCOM, BCom person having their services like accounting services, taxation services, for which these kind of the professional body has no role from whom they can take the NOC.
So then they can apply with associate, because and associates give an impression that the proposed company or LLP is a professional.
ये तो फिर ये specifically rule में लाना चाहिए कि only professional XYZ type the professional can use the word and associates.
At this point we have note down. We will take up with the policy cell.
Yes, that should be. That should be.
Yes, sir. Yes, sir.
And next question, how to obtain NOC from Council of Architecture to incorporate OPC, having the name and object for conducting architectural activity.
Yes,
the member director is certified architect.
So this is already taken care in our PPT as per MCA circular. The proposed company or LLP is required NOC from COA. This we have already covered. This is MCA circular.
Sir, already covered, sir.
Now I'm skipping 11 and 12 question because it is already covered. Duplication. I'm going to 13 number. Help kit of form run and INC 24 does not contain any probable or required list of document to be attached, and because of that different type of resubmissions are coming and delay cause. So there should be proper required list of the document to be attached with this in the instruction.
So I would require Harsha sir to give answer.
So INC 24 is related to the CPC, and the matter is related to the Harsha sir. Harsha, please.
So you are saying the required documents for the INC 24 is not mentioned in the form, right?
It's not mentioned in instruction kit.
Instruction kit. Okay. So we will update the instruction kit, but the rule is very clear. The rule for whenever the rule related to the change of name of an existing company, it is mentioned what are the things to be taken care of. I think ROC CPC must be while processing the form, they must be asking only those documents. Okay, they cannot go beyond the things which are mentioned in the thing. But anyway, we'll try to make that be incorporated in the INC24 instruction kit, the mandatory documents.
Okay. Question number 14. If ABC Private Limited Company wants to incorporate ABC LLP, the forms is not allowing even after attaching NOC and board resolution. ये
Sir,
कभी हो सकता
सर ये नाम चेंज करेगा, गैस करिए एबीसी प्राइवेट
नहीं चेंज नहीं कर रहा है, सेकंड एलएलपी बनानी है सेम
अगर नहीं अगर वो चेंज करेगा तो फिर किस में जाएगा, वो वही उसी में जाएगा जिसको हम नया बना, ये टू नियरली रिजेंबल है एज पर
identical sir. Same name, we are not allowing same name even if the company provide NOC. Here the case is if ABC Private Limited wants to incorporate ABC LLP. Let's suppose
yes, it is not allowed. No, I'll answer this query. See, the system doesn't distinguish between the LLP and company. We will remove these last two suffixes, whether it is LLP or limited or private limited, what these words, and after that the system checks. So already there is one ABC Private Limited is there. Even if it gives the NOC to the ABC LLP, that name will not be given.
Even though the promoter are same.
No, it's not the promoter.
Yes,
the entity is same. Tomorrow, for example, if the company wants to convert it into LLP, it will not have any choice. That will restrict the choice. That is the reason the same identical name will not be given for both the LLP and company.
Logical and good question, but we should incorporate these in the rule then. Because of sometimes क्या होता है कि हम as a professional sir
already mentioned.
I have already answered this one. See what
तो FAQ में कहीं डाल देंगे सर, इसको FAQ में डाल सकते हैं.
It's in the rule itself.
सर रूल में है ये तो सीधा.
बट हमने देखी है काफी ऐसी पास्ट हिस्ट्री में. अभी आप स्क्रॉल करोगे तो काफी चीजें मिलेगी.
We don't know how it might have been given in the past. Right now,
तो उसका क्लीनिंग का सर कुछ प्लान करना चाहिए.
Yes sir, yes.
Appropriate whatever procedure is with you, we will assist. जो भी इतनी सिमिलरिटी है जो पास्ट में जो हमारे सामने प्रेसिडेंट होके आती है, अभी जब हम बैठते हैं तो क्लाइंट बोलते हैं सर ये तो है, हमको क्यों नहीं मिल रहा है, इन 2-3 लोगों को मिल गया, हमको क्यों नहीं मिल रहा है. तो उसके लिए सर कुछ क्लींजिंग करनी चाहिए.
That is where your role comes. That is what I told in my inaugural address, that the professional community it is their responsibility, because they are well versed with the provisions of the law over a client who wants to do the business, who might have his own personal preferences in getting such names. He might have just checked in the master data or somewhere, you might have seen that name, but you are the one who have to inform them about the provisions of the law, because as long as it is not allowed by the provisions of the law, if you force the CRC or the MCA to do it, are we in a position to do it?
Sir, we can understand, but just the precedent is problematic.
See,
we are saying कि ये नहीं हो सकता,
precedents will be there, but an error in the past cannot make we cannot force that error to be regularized in the current and future, right?
And the rule is amended in the year 2019. So after 2019, it's itself provided in the rule. Might be it's not earlier in the rule itself, but after in the year 2019, we have restricted through rule itself that the same name companies are not allowed to be incorporated.
Yes, because if it is given tomorrow, that will not convert it into LLP. That is the logic behind the such
so the amendment. Examples given earlier is not valid.
Moving ahead with the next question, 15 number. The name approval queries specifically relating to the trademarks need to be rationalized. For example, class 25 relates to cover cloth and footwear. If client want to incorporate a company for footwear object, they are getting trademark similarity which are dealing in the cloth. This is irrelevant completely as per his question. So there should be some rationalization, because the trademark classification is sometimes too general with covering so many nature of the businesses. Sir.
Yes, please.
Sir, actually these type of queries we are raising in case where the proposed objects are not attached with the form itself. If they are choosing NIC, which is common in retail and wholesale of any activity, then which activity it's meant. We have already covered in the PPT. The stakeholder has to attach the object where analyses are very common. So you have to specify the specific object to ascertain TM query in a right way.
So you are saying that if we are having proper specific object,
Yes, sir.
though the class of the trademark are same or similar with the same name, but we can differentiate our activity by giving our object
Sir,
with the
yeah.
name of
Sir, we
activity.
differentiate,
You can
but
look into.
yes, sir, we differentiate. But if you read the
first
carefully our rule mentioned, है ना, 8AB, so it says that the in same class trademark will not be allowed. If you read, please. In
तो
same
इस
class.
मतलब आप ये कह रहे हैं कि मेरा
Yes.
फुटवेयर का कंपनी है,
Yes, yes. Rule. If you
वो
read,
मुझे प्रोहिबिट करता है, though
Yes.
they are not dealing in the
yes,
footwear.
yes.
Yes, a rule.
If you
rule
read the rule, sir.
provides, but
हाँ.
we CRC taken
We
care
are taking
of
care of it.
and we are looking into
हाँ.
subclasses also. But the rule itself provide only
Same class.
of goods and services.
So then what we suggest, मतलब do we think
can
that we
take
should
a matter with
go
policy
for
section.
changing in the rule or rationalizing that?
Definitely for
Please
changing.
take up appropriately at the appropriate forum then, because it is a practical hardship, na?
And second thing is the trademark is not related to us, so we just read the rule hours. Next, sir.
Yes. Next is 16. In 15 there is one second question is also there, that please provide the details of bank, provident fund number, ESI number to be shared along with the certificate of incorporation itself for the better compliance and transparency, if possible.
Yes.
How it can be done, because 90% cases client do not get proper details and documents in a mail in some time. So this should be looked into. Like we are incorporating PAN and TAN in incorporation certificate, there can be second page to the certificate of incorporation having these of the details.
Harsha.
Sir,
Sir, please, please.
I just missed it, sir. Can you
Yeah,
just
one question for that. In COI, only GST number and
Okay.
PAN number are allowed, but sir says that the ICPF number also may be mentioned in the COI.
Sir, that is not being mentioned because it is not generated in the real time. So
Okay.
this EPFO and ICS, this both are provided. It's an optional service because the GST number and these are optional. Being optional, they are not generating in real time. It may take around 15 days, 20 days for the concerned authority to approve it. Until that approval comes, if we make it mandatory, you will not get the COI. That is the issue. Even in current system, when where the PAN and TAN are generated in the real time, sometimes 1 or 2 hours delay happens. Because of that, we don't trigger the generation of the COI. In the meantime, the stakeholders raise that, okay, our form got approved and we have not received our COI. That is the reason we haven't made it part of the system. COI.
Sir,
Okay,
it
next
will
question.
take time. Yes, sir.
16 number. I have applied for a company reservation, name reservation, INIC India Private Limited. But the CRC raised the query having identical name, that is INIC and
Yes,
INIC.
sir. Yes, sir.
So thereby mentioning the INIC and INIC are
Both are different. It may be
but
some
technically both are different, and even though
sometimes
they have
checking
rejected.
error, sir. Poor checking, sometimes dealing hand, sir. So please, we are sensitizing and training our service and dealing hand and all officers. So please, है ना, file it.
तो stakeholder को मैं advise कर सकते हैं ना कि
Yes.
please file again with
Yes. Yes.
quoting reference.
On the merit, it will be done.
Okay. Now question number 17. Why was the name reservation application directly rejected without giving second chance of resubmission opportunity? Are there any specific situations or circumstances under which it is directly rejected in first case?
We give one chance, sir. In part A, we give one chance. In incorporation form, we give 2 chances. In LLP, we give 2 chances. So there is no
नहीं, but कभी ये हुआ है मेरे साथ भी, पर्सनली मैं बोल सकता हूँ कि ये मेरे साथ हुआ कि फर्स्ट टाइम पे ही रिजेक्ट हो गया, मुझे फ्रेश एप्लीकेशन
फिर आ जाता है, पुअर सर ये मतलब कभी हो सकता है सर, ऐसा हाँ, कभी कभी टेक्निकल ग्लिच कुछ ऐसा हो जाए, मतलब ऐसा है नहीं सर। आप जानते, आपने खुद ही फाइल किए होंगे सर इतने फॉर्म, तो ऐसा तो है नहीं कि कोई आपके हर सारे फॉर्म रिजेक्ट हो गए फर्स्ट चांस पे सर। सर प्लीज सर, अगर कोई आपका ऐसा
Hello.
केस है तो जी सर।
Yes,
हेलो,
next question, sir.
यस सर।
Question number 18. I had previously applied for a company name which was duly approved. However, due to certain reason, we could not be able to comply within the timeline, and we name got expired. Now we are going again for reapplying the same name or incorporating directly the company with facility direct incorporation with name. Despite of attaching this old name approval letter, so many queries are remarked or query raised regarding the name of resemble है ये है, तो इसका क्या solution है सर?
Sir, hypothetically we can't say so. If such case is there, I request to kindly email the SRN number to roc.crc and escalation mail.
Yeah, because different individuals might have processed, so that is the reason they might have taken a different stand. But yeah, that may be brought to the knowledge of the head of the office, so the consistency will be maintained.
Next question, sir. Can I go for next?
Yes, next
Hello?
question. Yes,
Okay,
please.
okay. If I apply for company name and there is no existing trademark on that name, but application rejected by CRC due to 50% resemblance to the name of another company that is engaged in completely different line of the business, what is the procedure to be followed in these cases?
First of all, sir, 50% identifying 50% is in itself is a great job, which the person who has sent this question has done. Secondly, I will request to this also needs to be seen as a special case, whatever it is, case to case it matters. So the SRN can be sent to us by email.
Okay, so in this case, it is stakeholder are advised to reapply with old SRN.
Not all, they can't reapply if it is rejected, and if it is there with them for resubmission, they may resubmit it, or they may email it with the new new SRN.
They may apply afresh and they may raise the issue with the ROC CRC.
They may apply fresh.
20.
If any discrepancy difficulty they face, they may send the email. I don't think anything 50% resemblance. Resemblance is resemblance. If it is resemblance or identical, percentage is not mentioned in the act or rules.
Generally, we
So,
don't quantify that resemblance,
yes,
trademark resemblance.
yes. So quantifying resemblance is in itself is a great task which has been done. Let's go ahead.
So I think it is कहाँ से उसने पिक किया stakeholder ने don't know, maybe उस पे उससे
ये अच्छी
बात
बात है, जो भी है, but we are here to resolve.
Okay. Next question 20. Why ROC is asking for board resolution from a company who already has given property on lease? As per incorporation rules and act, there is no such thing defined. It only asks for NOC and any utility bill of the ownership proof. Then why the extra document like board resolution is demanded? Is there any rule?
Sir, it is mentioned in the rules that in case the owner of the property is a body corporate, the NOC is required to be submitted in form of a board resolution.
If it is there in the rules, then the answer is clear, sir. I am agree with you. If it is there in the rules.
Yes.
NOC in case of body corporate should be in the form of board resolution.
So, sir, body corporate, yes, no, everything is in the form of board resolution.
The next question, we had submitted incorporation document in which we received 2 resubmission relating to KYC document. Upon final submission, our form was rejected, stating some altogether different reason regarding object are not matching and etc. So, however, the same was matching exactly. So please guide us on how to go ahead with this case, where previously the query raised something else, on resubmission addressing with that query.
Yeah, this may be
On
a unique
resubmission, the
case.
rejection is already on altogether different footing.
I'm answering.
Yes.
So, sir, such cases, we concede that there has been such cases in past, but we are vigorously working to eradicate this thing, piecemeal resubmission remarks. We are working so that entire form can be seen in a one glance, and whatever queries are there may be sent in one go. So we are taking as a homework.
ROC sir has already sensitized all the officers and officials to send all the resubmission remarks at a time. Even the ministry is also very particular about it. So that might have happened as a one of an instance.
However, at times the attachments are not visible, and it happens that we repetitively ask for attachment, and the attachment itself is provided in the last instance, or upon examination it is found
that time based on that new
not
attachment
fulfilling the
query
requirement.
might have been
It
raised.
may happen, but then we concede in most of the cases there has been seen that the examination was done in piecemeal. So we take our homework, we note it down, and we request the members also, today's participants also, to kindly take care of it.
Okay, so the second question,
Why
next question is similar to that.
Yes, please.
Why the CRC used to provide different remarks every time rather than going in all in one go in one resubmission? So it is similar to previous
same
one.
thing. It is a repetition.
Second question, next question is regarding Nidhi. After amendment in 2024, the company was incorporation of Nidhi company required prior approval of central government under Rule 3A. However, MCA is rejecting the name approval application submitted through Spice Plus due to non-submission of NDH-1A form. So can you clarify the correct process and timeline for filing NDH-1 and incorporation of the Nidhi company?
Yeah, sir, kindly refer MCA notification dated 16/7/2024 pertaining to Nidhi Amendment Rules 2024, which the policy section has recently amended the Nidhi Amendment Rules and provided that approval of central government is required through MCA headquarters.
To incorporate
Rule
the
has
Nidhi
changed in
company,
this
sir,
regard.
so we should first incorporate the company, not showing any Nidhi word or Nidhi object, a simple company. Then we should convert it into the Nidhi
After getting the approval from the central
after
government.
getting the approval from the central government, sir.
Okay.
You cannot incorporate as a Nidhi company at the incorporation stage itself, as per the recent amendments.
बट क्वेश्चन ये कि एग्जैक्ट प्रोसेस क्या, पहले कब फाइल करना है NDH-1A, कब फाइल करना है और इनकॉर्पोरेट कब करना है, उनमें
पहले कंपनी फाइल करना है, पहले कंपनी इनकॉर्पोरेट करना है,
फिर आपको सर अप्रूवल लेना सेंट्रल गवर्नमेंट से, सर, कि वी आर गोइंग टू मतलब
convert it into Nidhi company. So we are fulfilling all the criteria. Then I am making an application. You please provide the approval for conversion of the current existing company to Nidhi company.
Okay.
NDH-1 तो सर बाद में ही आएगा सर.
हाँ, तो बट वो नेम अप्रूवल में ही रिजेक्ट हो रहा है, ऐसा उसने बोला. इनकॉर्पोरेशन में रिजेक्ट हुआ है.
सर आपको नॉर्मल कंपनी बना,
सर, because they have chosen type as a Nidhi company, which is not allowed. They have to incorporate a normal company, normal private limited.
ABCD Private Limited, sir.
Sir, step 1 in this is to incorporate a company normal. Then secure central government's approval through NDH-1A. Then go for the change of name as well objects. So this, as of now, this is the procedure laid down. So it has to be done in 3 steps.
Okay. Now there are few questions just during this ongoing session. हमने receive किए. Can I take up this question?
Yes.
So how much time we do have, madam? आप technical team बता सकती है ICSI से?
Sir, we can extend up to 15 minutes.
Okay. In case of non-DPIN holder during the LLP incorporation, consent of DP required, but no separate attachment box is given. Due to this, many resubmission comes?
In case of a
Non-DP holder,
DP holder.
Yes, sir.
जो मतलब जिसके डीन नहीं है उसके लिए हमें कंसेंट के लिए सेपरेट अटैचमेंट बॉक्स नहीं है, उसकी वजह से रीसबमिशन आ रहा है. दैट इज द क्वेश्चन.
Separate.
But I think, sir, it's given in the instruction kit that you have to file the consent for the designated partner which is not having TPIN. Otherwise, we will take up the matter with e-governance cell and policy cell
Sir, please write down, write to
yeah,
mail to the ROC
to make
CRC.
this as a mandatory attachment in the form itself. It's true, sir, because of this reason, many Philip forms we send for resubmission. It's true. But we have to check with e-governance cell, or I request institute also to take up the matter with the ministry.
And also you can mail, sir, to ROC CRC.
Or we
So
will forward the request.
Okay. Next question is whether any other proofs other than electricity bill, mobile bill, telephone bill, or gas bill can be submitted as a proof of registered office? Because it is 4 options are auto-populated in a drop-down menu. That is electricity bill, mobile postpaid bill, telephone bill, and gas connection bills. The
Bank
4 categories
statement,
are.
we are accepting
registered
for
office.
registered office address.
Utility bill required, sir, as mentioned in the Rule 25 of Incorporation Law, like written that the utility bill required. In the utility bill, our
Only
electricity bill.
These are the options which is given in the form itself.
So is there any other one, like other than these 4 one? Question is specific. Let's say you just said internet connection bill may be subserved, the water bill can be subserved. Is it so?
Yes, yes. Sir.
Yeah, if it's issued by any government or central government or state government authority, then we will accept it.
Okay, any government
utility bill.
approved by government authorities, right?
Yes, yes.
Whom do we approach if the PAN allotted during conversion process from company to LLP is wrong in the incorporation certificate?
PAN or e-governance cell will answer.
E-governance cell, Harsha?
Sir,
please repeat the question, sir. Please repeat.
Please repeat your question.
मतलब इनकॉर्पोरेशन हुआ है कन्वर्जन के बाद कंपनी का और एलएलपी में से उसमें तो उसमें जो पान कार्ड आया है सीओआई में कन्वर्जन सर्टिफिकेट में वो रॉन्ग है.
रॉन्ग मतलब
अब वो क्वेश्चन में नहीं पता चल रहा है रॉन्ग का somehow कैसे रॉन्ग होगा.
The company will have a different PAN card which will have a 4th letter as a C.
Yeah.
LLP will have a F or something. So the income tax department issues a new PAN card. They might be thinking that they would have got the same PAN card. They can elaborate a little more. I can address this one.
So, do they have to approach somebody to correct it, or
if they want to get it, if they have any issue with that, they can directly approach the income tax department.
Income tax department local office.
Yes, because only during the incorporation stage only we get it generated as part of the MCA 21 registration. But after that, it is they have to consult the income tax department.
उसका सर्टिफिकेट ऑफ इनकॉर्पोरेशन परमानेंटली रॉन्ग पैन कार्ड बताएगा ना फिर तो ये थोड़ा
नहीं रॉन्ग मतलब नहीं
टू मच टेक्निकल है सर.
I got the point. See, what is the wrong PAN card? That is the issue.
That is what exactly I आपने जो डिकोडिंग किया, that is I agree. तो डिकोडिंग के बाद ही आप नया पैन कार्ड मतलब इसमें सर्टिफिकेट ऑफ इनकॉर्पोरेशन में देते होंगे ना, जैसे P है या L है, फर्म है तो F है.
That is what we automatically trigger when the incorporation is approved by the ROC officials of the CRC. Automatically through a signal will be generated and sent to income tax department. Then as per their rules, they will generate the income tax and they will just provide us. So we have a placeholder in the certificate of incorporation. That is where we just paste that number. So but we have no role. It is income tax rules they follow in relation to the PAN card generation. So if there is any issue with it, they may get it changed from there.
Okay, next question. We want to file name change application for a company to include the term financial in order to make necessary approval to RBI applications. However, CRC requires the approval letter to be given in name change application itself, which is not possible since the RBI approval come only after change of name.
Sir, as a lot of cases we have received that company is not NBFC but name is name having like NBFC. So there is a list on the RBI list, and we have guidelines from the ministry and in SOP that the name should be given prior approval from the RBI.
Correct. Because if they are given the name first, they may misutilize that name and they may do the deposit collection NBFC activities from the public. That is the reason for an existing company, they may approach the RBI to get this word NBFC approval or whatever the prior permission which is required from the RBI. Then that is submitted as an NOC. ROC will anyway process that word and that will be given as part of the company's name. It will not be other way around.
Okay. Next question. Same again relating to these kind of things. That is, we have received a RBI letter for NBFC COR, which also direct us to change the name of the company to reflect the financial activity. The RBI email confirming this was also attached with run application. Despite of this, CRC repeatedly raising the same query like finance, loan, fine serve are not allowed. Kindly clarify whether why this happening. Even we are changing the name based on the direction of the RBI.
In that case, it should not have happened. They should raise the issue with the ROC on a mail or something when this kind of.
FinServ word can't be given. See, RBI cannot decide. See, if word FinServ is given and RBI has given approval for use the word FinServ, we must appreciate that there is a trademark on word FinServ. Well-known trademark. So, see, RBI is not the parent authority to approve a name per se. They have given their consent to change the name, but name guidelines and name approval will be looked after by the office of CRC. So in this case, let me clarify at the outset that FinServ word already has a trademark, popular, so it won't be allowed.
But the rejection remarks should depict this. Na? Here the answer, you stakeholders saying then repeatedly raising the objection that these words are not allowed without the approval. मतलब आप जो कह रहे हो कि वो ट्रेडमार्क है तो वो क्वेरी में जाना चाहिए ना रिमार्क.
Letter
We mentioned that query itself, like we have a format that these names are not allowed. In the end, we write note and then we write the relevant point also.
The questioning person has taken excerpt of the remark. It's not the complete remark, I believe. And if it is so, the same may be forwarded to us by mail.
Okay. Due to inadvertence, if the category of company selected is wrong and name was approved, now how we can withdraw the name or change the category? Is it possible?
Sir, we have discussed the name and how to
change of name. See,
master data will not
that
New
it
incorporation, sir.
New incorporation is not the solution. And the procedure we have already discussed.
कैटेगरी के लिए भी हमें विड्रॉल ही करना है, उसका कोई फैसिलिटी नहीं.
We cannot change.
Whether the numerical is allowed as a prefix in the proposed name. Received query, kindly avoid use of numericals. Proposed name, we can check name basis on the alphabet only. तो इसके लिए क्या है आंसर?
It depends on the case to case. So as such per se, there is no prohibition on the use of numericals. It depends on whether it's having a brand is there. If it is a unique, the name is not resembling. Subject to fulfillment of rest of the other rules, it is allowed. It's not per se prohibited.
So we can have that kind of the prefix,
Yes.
numeral prefix. किसी को query आई होगी कि we do not have facility to check.
Maybe in past somebody might have faced such query. But then, as I said, it is subject to other fulfillment of other rules. So standalone, this is not sustainable.
Okay, please define, next question, please define exact meaning of word deceptive word, because ये बहुत बार resubmission में आता है. Please.
So please again file. Sir has suggested that please file if company having brand, and it also mentioned in the rule that company proposed name having brand and with prefix numericals, so it will be allowed. Company having trademarks proposed name, so no issue, sir. And our system will be improved because we have some difficulty in checking the name. If company having 1, 2, 3, so there is too much difficulty in system. We are also requesting, so we are, please file. So it will be decided on the basis of merit.
A question architecture related, I think what is duplication. Next question is, what is the NIC code to be chosen while reserving the name for Nidhi company?
Nidhi company, sir, nahi, sir. We have discussed already that we will not give Nidhi company. It will be in third stage. Then they will file after incorporation before taking approval from the central government for name as well as for object. First you incorporate the simple company, then get approval from our central government, sir.
Okay. Next question is, we want to convert a state cooperative society into company under criteria part 1 others, right?
Yes, sir.
However, the field is disabled in the form of SPICE part A.
Okay.
Please guide us on the name, on the same.
Ready, sir? Harsha?
Sir.
Please, sir, repeat sir question, sir.
Question is, we want to convert a state cooperative society into company.
Okay.
Under criteria part 1 other. But the field is disabled in the form SPICE part A. ये ज़्यादा मैं भी नहीं समझ पा रहा हूँ.
मैं बताता हूँ इसका. See, whenever a cooperative society or a trust wants to convert it into private limited company or public limited, as per the act, it is not directly allowed. So what they want to say is, in the part 1 others means there are only very few options are there. There is an option called Section 8 company. First, what they need to do is, from the cooperative society or the trust, they need to first convert it into the Section 8 company. But they directly want to convert it into private or public. The law doesn't permit it. First, they have to convert it into a Section 8 company. Then, after getting the Section 8 company, they have to go apply INC 2017 before the regional director for conversion of that Section 8 company into any other kind, maybe a public or private. After that, that can be done.
Okay, next question is, in case of just CRC asking for NOC in case of a company company is already owner of the trademark holder, right? Owner of the trademark.
Yes, sir.
So the NOC cannot be given to itself. However, CRC is asking for the same.
Sir, I'll explain you this question better. See, we have seen in some cases, an individual is holding, an LLP is having a trademark, and on the behalf of LLP, an individual DP is signing NOC. So this is not proprietary. If it is, the trademark is held by this LLP, then there should be a resolution. It should be in the form of resolution. So people are mixing.
कंपनी खुद को NOC देगी सर, ऐसा क्वेश्चन ये है कि मैं खुद को मेरे को NOC दे रहा हूँ for the change of name, though I am already owner of this trademark.
No, it is that can individual give body corporate
promoter has. Sir, there is lot of dissimilarities that sometimes company does not have. Sometimes there is some glitch. We just want that if any body corporate promoter has the trademark or company giving NOC, company cannot give NOC. We have seen many cases that companies said that this is our own trademark, but we check the trademark, it is related to the promoters or directors, so we cannot give it. So we need KYC documents of the promoter who has the trademark. Bas.
See, should I sum
मतलब
up it?
company का yes, pardon
See,
sir.
trademark is is the legal holder of trademark may be body corporate as well as an individual. In some cases, what we have observed, and an individual is giving NOC on behalf of a body corporate. So it is not permissible. You understanding? Because that body corporate is a separate legal entity. How an individual may be a member or promoter of that body corporate can give. So we ask by it should be in the form of board resolution
नहीं
with
sir,
that body
question
corporate's KYC documents.
understood. The question is not that a separate owner is there. Owner of the trademark is company itself, and company now wants to change the name to line with the trademark itself.
No issue, sir.
So here the NOC is again asked कि भाई आप
Sir,
NOC लेके
there
आओ.
may
मैं
be
खुद
some
को मेरे
specific.
लिए NOC मांग रहे हैं आप, ऐसा उसका question.
Sir, you can mail, sir. There may be some specific case. Otherwise, we don't ask.
And I'll
NOC
request
in
this
if in this
to
such type of the matter.
whomsoever has faced this discrepancy, kindly email us.
Yes, please, sir.
We will definitely get back to you.
So now last question. The company
Yes.
was incorporated in 2000. Specific थोड़ा different question है इसलिए ले रहा हूँ. Last question. Company was
जी.
incorporated in 2010 and has not commenced any activity since then. And the company is regular in filing all the returns with the ROC, but there is no income, hence there is no PAN card allotted to the company as of now. Now, company wants to apply for PAN card, but the authority are suggesting that please approach to the Ministry of Corporate Affairs. Is there any provision to obtain PAN card from MCA?
No,
There is no provision in MCA for applying PAN card of existing company. This is something altogether unique.
Yes. Absolutely no.
और अब जब हम इसको कन्वर्जन करने के लिए जा रहे हैं तो हमसे इनकम टैक्स मांगे जा रहे हैं, बट हमारे पास पान कार्ड ही नहीं है तो हम इनकम टैक्स कैसे देंगे? So this is something
They should consult income tax department and get their PAN assigned first. Then they come back to MCA so that we
That is
will
what
link it in our
a deadlock has
database.
been created. A deadlock is created.
We will link it in our database.
अथॉरिटी ने बोला आप एमसीए के पास जाओ, ऑलरेडी ये क्वेरी में
नहीं MCA का पास कैसे जाएगा? MCA is not the authority to issue.
I agree sir, I agree, but क्वेश्चन आया है तो we have to answer it. So we concluding this, any concluding remarks from anybody, from officers or technical team?
This session was, I think, very helpful for us at least to know the grievances public is facing, and we take note of all the grievances, and we commit that we will not repeat anything, and we will try to rectify all the defects at our end. At the same time, I request all the stakeholders also to kindly listen to our concerns also. Commonly made reasons by which the form is coming for resubmission and remark may kindly be avoided, and it will definitely ease our workload, and that will eventually lead to faster disposal of your applications. So it will bring quality and speed into the efficiency to the system. With this hope, I thank you, all of you. Thank you.
Okay, thank you very much, sir. I formally conclude this webinar, useful webinar. Many users might have cleared their queries and resolved their issues, or many still may be there. They are requested to approach to the appropriate authority or through proper email system, or they can write to the ICSI for compilation. And Deepa madam, I request you to please compile if now any queries are still pending, so we can forward to the MCA for these kind of the second webinar if enough query is with us. And I also specifically thanks to the President, ICSI and Council members and team behind this for organizing this webinar. I also thankful to Anil Yadav sir, Sir Ali sir, and Bidni Eboroi for giving insightful knowledge and technical expertise they have given, and logic behind these every resembling and all name related queries and incorporation related queries. And at the ICSI, we are there to handle with you. And I may also request the member, please come with constructive suggestion to proper channel. The MCA is open to take all these things. and ICSI is between them to bridge the gap. Thank you all. Thank you once again, and be participative. Thank you, sir. Thank you. Thank you, sir.